All right, it's 11 o'clock. Let's roll. Thank you so much, everyone, for joining in. My name is Vishal Sharma, and I'm your moderator for today's session. I am joined alongside Prashanthi Reddy. Prashanthi is an alumni with University of Pennsylvania Law School. She has been in the field of immigration since 1997, admitted to the bar in New York. She is a member of the American Immigration Lawyers Association and the New York Bar Association as well. She holds the position of immigration chair for the National South Asian Bar Association and immigration co-chair for the Federation of Indian Association as well. She is currently actively involved in pro bono legal work alongside everything as well. So on that note, Prashanthi, thank you so much for joining today's session, and over to you.
Thank you, Vishal. Can you hear me?
Yes, thank you.
Perfect. Let's start the session and people will keep joining. Okay, so let's start with the immigration updates. I think we should start with the visa bulletin. If you can go to the next page, the visa bulletin. Yeah, so for the May visa bulletin, which came out, last week, early part of April, the first week of April, I think around the 10th or the 11th is when the visa bulletin came out. There is really not much of a change, which is good news and bad news. Good news is it hasn't retrogressed. The dates remain the same for Indian nationals EB1, EB2, EB3, and for worldwide as well. The USCIS has said that for employment-based cases, we should be using the final action dates. So no longer we won't be using the dates for filing anymore. It's the final action dates, and with reference to the visa bulletin, just backtracking a little bit to explain to those who don't know what the visa bulletin is and what it's all about, is the visa bulletin is issued once a month, and it gives you an idea of the availability of green card numbers in the employment-based and the family-based categories. There is a limited number of green cards available, issued every year, and therefore often the numbers become unavailable. And when you file your green card, it may be backlogged, and it may take a while, especially if you're an Indian national, to actually get your green card, because your green card number may not be available. The number is decided based on the priority date. The priority date is determined based on the date that you file your labor cert, if you're doing a regular EB2, EB3 kind of case. Or if it's an EB1 where you're not actually filing a labor cert, or in some instances a national interest waiver EB2, the priority date is based on the date that you actually file the I-140. For family-based cases, the priority date is based on when you file the I-130, the immigrant visa petition. So that's your priority date. So what you need to do if you have a case pending is keep an eye on the visa bulletin every month. It comes out around the 11th or the 12th, between the 10th and the 12th of every month for the next month. So they usually let us know in advance what the availability will be for the next month. So there are two tables on this visa bulletin. The first table is the dates for filing table, and the other table is the final action date table for both employment as well as family-based. Now, what do those two tables mean? The final action date table is the dates that are actually available, the priority dates that USCIS is actually working on. So that's accurate and correct date. So the dates for filing are here. The Department of State is allowing you to file your green card ahead of the availability of your priority date, because they reckon that by the time your 485 is filed and processed, your priority date will become available. So when it's very close, basically they allow you to file in advance, and they have different dates for that. Those are advanced filing dates. So either way, you can file a 485, and either way, you get the benefit of EAD, that's employment authorization, and advance parole, which allows you to travel. But when you file based on the dates for filing, which is the advanced filing, your green card doesn't actually get approved. It just remains pending until your date becomes current as per the final action date table. But if you file your green card based on the final action date table, then they'll process it immediately, and it's just the processing time then because the visa number or the green card number is available. But there is a processing time either way in both instances, which is about 10 to 12 months. So the trick is that the processing time should remain current until they actually process your case. So that often doesn't happen, because if they're taking 10 to 12 months, somewhere between that time, it may be current at the date that you filed it, or might have become current somewhere in between, but they have not really had the chance to process it, and it again becomes backlogged. So that happens as well. So that's about the what happens with the visa bulletin every month and what a visa bulletin means. So just a little bit more information for Indian nationals and Chinese nationals. The visa bulletin is often backlogged for the EB1, EB2, and EB3 categories. EB1 is the best. Fastest way to get a green card is EB1, and then it's EB2, and which is advanced degree holders and people with a bachelor's and 5 years of experience, and EB3 is just bachelor's degree. That's if the job has to require that experience and education. So that's about the visa bulletin. This month's visa bulletin, as I was saying earlier, not much change from the previous month, but at least it has not retrogressed. What to expect the rest of the year for the visa bulletin? Usually the visa bulletin, the fiscal year ends in October, and the new fiscal year starts in October. It ends in September, and the new fiscal year starts in October. So as the months pass by, you will see that there will be a retrogression as the year ends. In September, there will be a retrogression, maybe in August as well. So far, we haven't seen any retrogression. We don't expect any advancement unless at the end of the year, Department of State has seen that the numbers have not been used, and that's an unlikely scenario. If they see that they have not been used, then they might advance the dates. But generally, there's a retrogression towards the end of the fiscal year. And in October again, we see that there is an advancement. Two things happen. There's an advancement in dates because then the new numbers come out for that particular year. And also what happens is, the dates, the final action date table can be, the dates for filing table can be used, sorry. The advanced table, they allow usually the advanced table to be used for a few months until at least March or April from October. So this is a little bit about the visa bulletin for those who don't know anything about it. You have to go to travel.gov to find the visa bulletin, or you can just type in visa bulletin May or visa bulletin, whatever month you're looking for on Google, and you'll find it. So now that we're done with the visa bulletin, let's go to the next slide. So today's presentation was with reference to H-1B cap RFEs. We all know that the H-1B cap cases have, you can start filing them as of April 1st. A lot of people are filing their H-1s. And this is the time to look into your H-1, make sure that you file it properly so that you can avoid an RFE and ultimately a denial. So we thought we'd actually we'd do just an AMA session, but we figured let's have a short presentation first with reference to how to file a H-1, because that's apt for this time of the year. And all of you must be filing your H-1s, and then we'll go to our Q&A session. So the first, what to expect with reference to RFEs this year. Every year CIS changes the way it does things. The rules, sometimes they have new regulations, sometimes they interpret the regulations that are existing in a different way. So what do we expect for this year? For this year, the same as last year, at least for the beginning of the year, I think. I don't know if it'll last until June or not, but we expect the same as last year, which means that USCIS will mostly be sending RFEs if they do send RFEs, and we haven't received many RFEs last year. They will send RFEs on specialty occupation. They might send RFEs on maintenance of status. And these are a few things that we're going to cover today. They may not send that many RFEs on availability of work. Now, that's a big issue, availability of work, especially in consulting situations or in IT company situations where the person is consulted out to a third party, and also in situations where you're actually working for the client. They want to know if the employer has sufficient business to require that job in the specialty occupation, if they have enough availability of specialty occupation work. Now, this was a huge issue in the previous years, but as a result of, in 2020, there was a lawsuit, ITSO versus Cessna, as a result of which USCIS is asking that question less and less. Otherwise, they would ask for purchase orders, contracts, proof of doing business. And they would also ask for, especially in consulting company situations, POs for the entire duration of the 3 years. If you're applying for a 3-year, if you're applying for a 3-year extension or a 3-year H1. Not so much now. Last year and this year, there are a lot of IT companies that have filed skeleton petitions, and they've been approved without a PO, without an MSA. Without mentioning a client, and USCIS has not sent RFEs on those cases. They've sent RFEs for other reasons, but I have not seen RFEs for lack of POs or MSAs. But having said that, there is a new proposed regulation that's coming up. And in this regulation, the plan is to bring back those POs, the request for POs and work orders and MSAs. So the availability of work, RFEs might come back again if that regulation is passed. It's right now a pending regulation. Part of it has been passed for the registration, to change the way registrations were done. Now we know they're beneficiary centric. It was part of the same regulation. So they've fast forwarded that portion of it, but the other portions where they're asking for information and some changes with specialty occupation, etc. They have not yet finalized them. They have not published them. So let's see what happens. If that happens, then we can expect a change this year itself in the way CAP cases are filed. So far, so good. My only advice to you is file as soon as possible before the new rule comes out. File in premium processing so that you don't get affected when that new rule comes out, because it's only a question of when. So going back to our presentation with reference to what to expect this season, as I was saying, the most common RFE that we will get this season is specialty occupation, which means that if USCIS is not certain of whether your position requires a bachelor's degree in a specific field, they will send out an RFE asking you to prove that your job is a specialty occupation. USCIS has narrowed down its interpretation of what qualifies for a specialty occupation in many instances. They have said that if more than one degree is required, for example, if, say a data engineer requires a bachelor's in math, statistics, engineering, computer science, then they might say that, these are all fields that are not related. Therefore, it may not be a specialty occupation. So we have to be careful when we decide on the job title, and also we have to be careful in our job description. No matter what the job title says, the job description has to clearly mention what the duties are, so that they actually look at the duties. So if they see that duties are administrative and not complex enough to require a bachelor's degree, even if you put a software engineer title there, which is recognized as specialty occupation by USCIS, looking at the duties, if they're not written properly, framed properly, then they might still deny the case. So make sure you put in those duties which shows complex job requirements, and Also, make sure you decide the job title wisely. And when you're when your employer is writing the petitioner letter, make sure that they put in, a bachelor's degree in a specific field is required, not, putting 10 different fields out there. So they shouldn't say engineering, computer science, math, physics, science, they should just say computer science if it's an IT position. So that's extremely important. Next slide. The other reason, as I was saying previously, would have been availability of work. They're not asking that so much, but I would caution those filing a H-1B petition to ensure that there is sufficient work available for your employee before you file a H-1, because they might ask it, and also it's required. It's a law. You can't file a H-1 based on speculative employment, which means that you can't say that, okay, once he comes to the country on a H-1 or once he changes and gets on my payroll, that's when I'm going to start looking for work for him. So that doesn't work. So just make sure you don't do that. Beneficiaries qualifications, of course, I mentioned that you have to have a bachelor's in the specific field. So in that particular area that you're doing your job, again, give the example of the software engineer, you have to have a bachelor's degree in computer science. If you don't, then a closely related field such as information systems, information management, software engineering, etc., management, information systems, MIS. If you do not, say you have a bachelor's degree in electronics engineering, you could also then get an evaluation done showing that you have the equivalent of a degree in computer science. Equivalencies are done by getting a work experience evaluation done by an evaluation company. They will combine your education and 3 years of work experience, and they will determine that you have the equivalent of a degree in computer science. Another reason why you could get an RFE, and therefore you should be careful while filing the petition, is maintenance of status. If you're on an F1 especially, or any other status and you're changing status from an F1 to H1, H4 to H1, maybe B1 to H1, you have to make sure that you are in status. You have to make sure that you submit all the documentation showing that you're in status with the initial filing of the H1. So all your I-94s, and if you're on a H4, then your spouse's H1 approval, your spouse's pay stubs to show that they're in status. This is what's required if you're filing for a change of status from a H4 to a H1. For an F1, again, there's a different set of documents required. You have to submit your I-20. You have to submit proof that you're presently in school, and that you're in good standing, maybe a letter from your school, proof that you've paid all your tuition fees. If you are on a CPT, then you might want to present documentation showing that your school required you to be on a CPT, especially if you took a day one CPT, that your school required you to take a day one CPT because it was part of your coursework, especially if you're doing an executive MBA type degree, where where actual work is, given credits as part of coursework. So maintenance of status is a big issue, especially for people who are on an F1. Next slide. Availability of work, as I said, again, this is if you have work within your company, then you have to show that, and if you're not working for a third party, then you have to just show that your company has sufficient business. So you would show maybe the financial documents of your company, like the tax returns, to show the volume of your business, maybe your active contracts. You would show that you have a premises where work will be performed, so a copy of the lease. They don't like companies that have only virtual offices. Keep that in mind. They need an actual physical brick and mortar office, because there are a lot of posting requirements that have to be done. The LC has to be posted, and files have to be maintained. If audits happen, they have to have some place that they can come to, visit the office and see the files. So important to have a physical location. Also, when you're filing your H1, make sure your LCA is correct. Your labor condition application is a document that is approved from the Labor Department. And that has to be approved before you can actually file your H1, and that LCA is submitted along with your H1. So make sure that your LCA is approved and the information in your LCA is correct. The job title is correct. Your work location, very important, your work location site is correct. The prevailing wage is correct. So all this information cannot be changed later. If you file it and the information is incorrect, then you will have to withdraw the H1 and then file another LCA and then file another H1. Because once the H1 is filed, you cannot file another LCA or amend your LCA. Next slide. Also, often you might get an RFE for the 6-year term limit. A H1 is available only for 6 years. And this is most often in the case where not in a cap case so much, but in a regular extension case or a transfer case, if you have your 6 years are over, then you have to submit documentation showing that you have a reason why you're filing. So there, you can file beyond the 6 years in certain circumstances. One is if you have a labor cert approved or pending from at least the past 1 year, then you can get a H1 for 1 year. If you have an I-140 approved, you can get an extension for 3 years. If you have time spent outside the country and you have not spent the actual 6 years in the country, maybe you took vacation or you maybe took some time off and you left the country, you can recapture all the time that was spent outside the country. So these are some ways that you can get an extension beyond the 6 years. Can we go to the next slide? The fees is another reason USCIS will send an RFE or might sometimes reject the petition. When I say reject, the mailroom will reject the petition without even looking at the merits of the case. So this is one thing to watch out for. The fees are very complicated. They've always been for H1, the fees have always been complicated, and now even more so because the fee is increased. And they've added another additional fee called an asylum fee. And you have to actually, and it's kind of, if you're not familiar with immigration law, it's tough to figure out what the fee will be because they're in different places. It's not all in one document. So please be careful when you're sending out your check. You have to pay the regular basic fee. You have to pay a fraud fee. The basic fee is $460 if you are 25 or below, and it's been increased, I believe, to $780 if it's 25 or above. And you also have an asylum fee, a new fee, which is $600 if you are above 25 employees, and it is $300 if it is below 25 employees. Then you have the existing fee that used to be there, which is $750, $1,500. Again, $750 if it's below 25 and 25 employees. And then you have a $500 fraud fee, which everyone has to pay, unless it's an extension. So you see how complicated this is. So you really have to watch out for those fees. And also simple things, even if you get the fee right, make sure you write the check correctly and make sure you put separate checks for each fee. Don't add everything and put it in one check. So you might end up sending 3 or 4 checks to USCIS for all the different fees. So do that and make sure you sign the check, write the correct word, write the date. Otherwise, your case will come back. So that's about the fees. Next slide. Some basic best practices for RFE responses. Make sure if you do get an RFE, sometimes it's difficult to avoid an RFE because they are sometimes random. So if you do get an RFE, read the RFE carefully. And if you don't understand something, I suggest to use an immigration attorney if you get an RFE rather than trying to respond by yourself. Don't panic. just because you received an RFE doesn't mean that the case is going to get denied. It's just that USCIS might have some additional questions, and most often than not, a response to an RFE does result in an approval unless you don't respond correctly. Make sure you read the RFE completely, because there's a lot of information in there, which is just they're talking about case law, they're citing the case, they're citing the law, and it's not about what they're asking. What they're asking, the questions will be hidden somewhere within all this information. So if there's a 3-page thing, you might just have 3 lines of information that they're asking for. So please make sure you read the entire RFE carefully. It might seem that it's all information that is not useful, but sometimes they hide questions within within the rules that they're citing. And you don't get a second chance to respond to an RFE, so don't respond in parts, don't read only parts of it, read it entirely, and respond completely to every single thing that they're asking, to the best of your ability. Whether you have documentation to respond to it or not, you still need to respond. Either saying that you don't have the documents, or saying why you don't have it, or submitting alternative documents that you think might be useful. Whatever it is, make sure you respond. Make sure you double check the mailing address, send it to the address that they mention. It's not anymore the address that it comes from. Sometimes they ask you to send it to this different address, and that's usually mentioned in the last page of the RFE, so make sure you read that. If you send it to the wrong address, it may not make its way on time, it may not make its way at all to where it needs to, and your case might get denied. And talking about making its way on time, don't submit your RFE in the last moment. Send it at least a week before. Send it by FedEx next day or courier. Don't send it by regular mail, because this is important and it might get lost in the mail. So make sure you have some way of tracking it when you send it. And that usually, that's why courier is useful. And send it by next day if you can. So do all these so that there's sufficient time, even if there's some delays for USCIS to get your RFE on time, because they do not extend the RFE deadline, and that will not sending it on time will result in a denial. Next. Sometimes you might get a notice of intent to deny. These are different from RFEs. They're more serious, because here the officer is actually intending to deny your case, and they're sending you a 30 days. They're giving you 30 days to say why they shouldn't deny your case. So it's more serious than just a simple request for further evidence. They look at something and they think that they should deny it. They're giving you a chance to submit documentation so that they can change their minds. Again, in this instance, notice of intent to deny, there are often denials in these situations, but sometimes if you're able to submit documentation to overcome whatever findings that are in the notice of intent, it's possible to get an approval on a NOID as well. I think with that, we should be done. Next slide. Yes.
Yes, we'll open it up for Q&A right now. And as a token of appreciation for joining today's session, we will be offering a complimentary session as well, a consulting session. So if you are interested to put your name in that early bird complimentary session, do drop us your email address in the chat window, and one of our team members will reach out to you. All right. On that note, I'll start taking questions. First question we got is, my company applied for lottery under the master's cap, but my application got picked under the regular cap. I graduate in December this year, but by the time my company filed for the petition, I would not have graduated. Can my company file the H-1 petition with only my bachelor's degree and work experience? I have 7 years of work experience.
Well, the work experience doesn't really matter. The issue here is you filed under master's and you didn't qualify for the master's cap when you filed, but lucky for you, you got picked. You didn't get picked in the master's cap. You got picked in the bachelor's cap. So your notice will basically say bachelor's cap, and you're not filing under the master's cap. So I think you should try to file. This is a gray area, and for sure, if you would have got picked under the master's cap, there would have been no point in filing your petition because it wouldn't get approved because you don't qualify. But in this situation, I think you should definitely file. The worst that can happen is that you lose the filing fee, and the case will get denied. So there's no harm in trying.
All right. Next one is, can someone on F1 student visa first year apply for H-1B?
Yes, anyone can apply for H-1B. I mean, it's possible that you have a bachelor's degree already based on which you qualify, and you should file under bachelor's cap, and you should be good to go. And it doesn't really matter that you have not finished your, I mean, I guess the real question is it okay to leave school after the first year and not continue school? Yeah, that's fine as long as you're maintaining your status. As of the date of filing, once you get your H1, you can transfer from an F1 to a H1.
Okay. Next up is, what is the rate of visa granting to applicant of H-1B?
When you say visa, do you mean visa given at the consulate or visa H1s approved here? H1s approved here. Most H1s are getting approved if they're filed properly. As I was mentioning in my presentation, after that, basically after the Biden government has come in, they've, become more lenient with approval of H1s. During the time that Trump was president, we had a lot of issues and a lot of denial. The denial rate was really high. Now it's not that anymore. Most cases get approved unless there's something fundamentally wrong with them, and that we're usually able to. We usually have an idea when we're filing the petition whether it'll be approved or what the chances of denial are. So it's quite predictable, which is thankfully the H1, unlike other visas like the L1 and some other visas, the H1 is quite predictable. Yeah. So with reference to visas, if you're talking about consulate, again, majority of visas are approved, but there'll always be denials, and it's difficult to predict. Usually what I've noticed is just before cap season, the Department of State will deny a lot of visas. Always happens because they're trying to warn people not to file frivolous H1s, I guess, or scare people a little bit. So yeah, I've seen the rate of visa denials go up this month and last month as well, and the month before that. So that keeps changing, of course.
Okay. Next one is a long tail one, so please stay with me. Question is on the time limit for applying H-1B cap exempt to use remaining H-1B time period. I had my H-1B petition approved from 2014 October to May 12, 2018, and I'm on an H-1B job from January 26, 2015 to May 12, 2018. My company applied for an H-1B extension in March/April 2018, but my petition is pending with USCIS till 21st December 2018 and was later denied, not revoked. Since my H-1B extension is pending, I continued my H-1B job and I was paid till December 31st, 2018. Later, I left the country in January 2019. Under brackets, 240 days rule. I have my last payslip and 2018 W-2 and W-2 2019. Now, I'm on H4, came in November 2023 to the USA, and I want to apply for H-1B cap exempt to use the remaining 2 years of my H-1B. Under brackets, I don't have my I-140 done. My question is, until what time am I eligible to apply for H-1B cap exempt? I read in one forum that that to apply for H-1B cap exempt applicants should be in H-1B status for the past 6 years. The link is below, and then they've shared a link. And then, so should I apply for my H-1B cap exempt before May 12, 2024, under bracket 6 years completion, or even I'm eligible post May 12, 2024 till December 31st, 24, or after December 31st, 24. Basically, what is the time limit in my case to use the remaining 2 years of H-1B? All right, I'm done.
Wow.
Over to you.
Okay. This is like a whole presentation. But yeah, a lot of information has been given. But I think it just boils down, after all this information, it just boils down to one thing, whether he's cap exempt or not. And whether he needs to wait for the 6 years, he or she needs to wait for the 6 years, Bhaskar Reddy, yeah. Whether Bhaskar needs to wait for, needs to file the H1 before the 6-year period is over, or can file even after that. And that's a good question that I may not know the answer to. But so with reference to cap exempt, it really depends on their interpretation of what USCIS's interpretation of who is cap exempt and who is not. And this has changed over the years. Sometimes they use a more liberal interpretation, and sometimes, I remember a few years ago, one of my H-1B cap exempt cases got denied because they said that the person never worked on the H-1 and therefore they're not cap exempt. So there've been, varying degrees of what USCIS says as to who is cap exempt and who is not. Now, until recently, I would have said that because it says in the regulation that if you should have been on a H-1 within the last 6 years to be cap exempt, I would have said that you should file within the 6 years. And anyway, in your situation, I think you should. Why take a risk and not file, right? You might as well file if you have the chance of doing so within that 6-year period. That is, if you were last on a H1 in 2019, 20, 21, 22, 23, 24. So you were on a H1, last on a H1, I guess, in 2018. 18, 19, 20, 21, 22, 23. So yeah, it's, December will be within 6 years. I suggest you file before December. But also I wanted to let you know that I filed a cap exempt petition after the 6 years period was over and it got approved. So I think they're being very liberal with what they think is cap exempt and what is not. So they're not even considering the 6-year period, but that might be a one-off. There might be another officer that you get might say that, oh, you didn't file within 6 years that you were previously on a H1 and therefore you're not cap exempt. So to be cautious, I would file within the 6-year period.
All right, thank you for that. Moving on to the next one. I'm currently on post completion OPT, which has validity till 31st July this year. My employer will be filing my H-1B petition as my name got picked up in this year lottery. Can you please advise me on the following? 1, while my H-1B petition is prepared and submitted by my employer, can I simultaneously apply for my STEM OPT extension?
Let's answer one question at a time. Can you apply for STEM OPT extension? You have to decide, I guess, what you want to do. I don't know why you're putting your trying to go into, ride in two boats at the same time. Are you afraid that your H1 may not be approved? It'll be messy if you're filing two things. Again, it comes to the last action rule. What action you took last did you file? Because once that gets approved, whatever you did last, that becomes your status unless you withdraw it. And if you file for STEM OPT extension, withdrawing that, you could withdraw it, but they might not sometimes USCIS might just ignore that withdrawal request. You could file instead. What you should do is, if you're not sure as to whether you want to be on an F1 or a H1, you should just file your H1 for consular processing. And that way you can decide when you want to move to a H1. But remember, your cap, you will not be able to make use of the cap benefit if you're not filing a change of status application. So you will then be out of status because your OPT is expiring in July, right? You said July. So your H1 will not start until October 1st. So that's a problem. Yeah, next question.
Next is, once my petition is approved by USCIS, can I transfer my H-1B to a new employer without the need of going out of US and getting the H-1B stamping?
Yes, you can. Once you get a H1 approval, you have to start working on that H1. You have to get paid on that H1. And once you have pay stubs, then you can file a transfer to another employer as well. And this is a transfer that can take place within the US, and you don't have to leave the country or go for stamping if you don't want to. So I guess that's the only two questions he has. So going back to the first question, yeah, with reference to whether he should or should not file for a change of status and to a extension of a STEM OPT and a H1, I suggest not to do that unless you have compelling reasons to do so, because then your status becomes messy. You don't have control over your H1 because that's filed by your employer, so they may or may not withdraw it at your request. Your STEM OPT extension, I mean, I guess you can file it and then withdraw it if you don't need to. But again, USCIS sometimes may not withdraw or acknowledge the fact that you've asked for a withdrawal. So that's a little tricky. If they don't, then even if your H1 gets approved, you might end up being in F1 status. So it's a little tricky. I wouldn't do that.
All right. Next question is pretty much on the similar lines, actually. Can we transfer H-1B from one employee to another employer without entering into the US once stamping done?
Oh, so this is different because they're outside the country. And they're asking if they can transfer. So this is not called a transfer. You have to basically file another H-1B petition, and it will be cap exempt since you previously filed a H-1B petition and it was approved. And you don't have to go for a visa again. You can use the old visa and use the new H-1 and come into the country on the new I-797 approval.
All right. Next one is, I have graduated in December 2023. I am currently on F1 OPT. I have joined full-time in March. Due to shortage of time, my company didn't apply H-1B, but my H-1B lottery got picked up from consultancy with whom I was tied up before joining full-time. Is there a way for my current company to file H-1B on my behalf, or should I let go of H-1B if I am not willing to join consultants?
This is from Apurva. You should, you really can't, you can't have it both ways. So you have to decide what you want to do. If you want to file a H1, then you have to join that company that's willing to file the H1. The company that you're working for presently cannot file a H1 for you since they did not do the registration. So you have to decide what you want to do. It's not easy to get picked. In the cap nowadays, maybe you want to file a H1 consular processing, and that could solve your problem. If you file the H1 consular processing, you don't have to immediately join that other employer, and you can keep your cap exempt situation. You can, since you're already counted towards a cap, you can use that at any future point of time. So that might be a good solution for you to do. File your H1, file it consular processing, And then you have to join the consulting company at some point, and then you can file the other H1 as gap exempt with your second employer. So there's a possibility of doing that. Was I clear, Vishal, or should I explain that again?
No, I think that was good. Yeah. And again, this is again a good opportunity for me to emphasize for some of you who are looking for further clarification. It'd be a good idea for you to go on our website or reach out to us on LinkedIn and book a consultation. Next up is I have 14 years of experience with respect to tech business analyst and scrum master. Can I go ahead with the 3-for-1 rule substantiating my experience as I don't have a valid graduation? When we, I'm just trying to see, yeah, it is the continuation. When we mentioned that going by 3-for-1 rule, still I get RFE asking for certificates. Please clarify.
So I don't know what you mean by valid graduation. You have to be more specific. If you have a 3-year degree, then we could use the 3 years of work experience to get you the equivalent of a 4-year degree, provided that you have experience in your field. It seems like you might. So it really depends on what you mean by valid graduation. If you don't have a degree at all, then you would need much more experience. You would need 12 years of experience, which you seem to have. And you'd have to get an evaluation done showing that you have the equivalent of a degree based on all your experience. Sometimes USCIS might send an RFE even if you get an evaluation done, showing how you qualify, and you just have to take it as it comes. But it is possible.
Okay. Next is, I was picked for the H-1B lottery and my company is filing the petition. What are the options for my wife to work in US as soon as possible? Apply for STEM courses with F1 or look for opportunities on H4 visa. She is a computer science engineer with 4 years of experience in IT.
Well, she can definitely file for an F1, but remember the F1 is not, you don't join school so that you can work. And a lot of students seem to be doing that, and USCIS is getting wise at it. So I would caution you about that. The intent has to be to study and then, work, after you've finished a semester or so, or maybe as required by your course. Okay. And then with reference to H4, she cannot work on a H4 EAD unless you have an I-140 approved. So you have to go ahead and file your green card, your labor cert, I-140 as soon as possible so that your spouse can work. Otherwise, she can also apply for her own H1 registration next year and see how that goes.
All right. I like this next question, very short, crisp. Is IT project manager a specialty of occupation?
Question is short, but answer may not be short.
That's for you.
Yeah, that's for me. So IT project manager, yes, it is a specialty occupation. It does require a bachelor's in computer science. What they do is USCIS looks at a book published by the Labor Department called the Occupational Outlook Handbook, OH. That's available online. You can just Google it. And you can type in, then once you get to the OH, you can type in your job title and see if it's listed in there. And if it is, then they usually mention educational requirements for each position, and USCIS looks at that. If it's not listed, then we'll have to look for other sources. So a project manager generally is a specialty occupation because as per that book, it requires a bachelor's degree in computer science. So you should be good. But of course, remember that the job description is important. So when you're writing your job description, make sure it matches with the job description of a project manager, and it shows that the duties are complex enough to require a bachelor's degree in computer science.
All right. Next up is, I got selected in lottery this year, and company is filing my papers for H-1B petition approval. However, company is asking to get your education evaluation verification by submitting my degree/diploma transcripts to a certified agency. So, is it mandatory to go with it?
I suggest you do it, Nishit. I suggest you do it because USCIS is sending out RFEs if you don't send out evaluations, and not in every case, but maybe 1 out of 5 cases, they do send out RFEs asking for an educational evaluation, especially if you have if you have an Indian degree. Even if it's a straightforward degree, they are asking, you to submit an evaluation. Go ahead and do it.
All right. Next is, can I apply for a US work visa without a job offer? I'm failing to secure a job offer while I'm outside the US.
You need a job. You need a job offer if you have to file for a H-1. So yeah.
All right. Next is just a follow-up question on my case. Okay, I need to go back if there happens to be a follow-up question on that. All right, so I'll just continue here. I have finished most of the course requirements, but left with only 2 credits of industry practicum. If I get a letter from my school saying that I have satisfied all the requirements of the master's degree, should I apply with the master's degree?
If you have completed your, if you get such a letter, then you have completed your master's degree, even though you're not required to have a degree in hand, but that letter should be sufficient for you to file. This is the person who applied under master's cap, but got selected under the bachelor's cap, I think. So yeah, you should be able to file because there's no issue really then.
Okay. Next is, my wife has H4 interview scheduled on May 10th in India. She got selected in H-1B registration in FY25. Once she got stamped with H-4 visa, is she eligible to drop box for H-1B visa?
Yeah, that's the drop box is if you've previously had a visa in the past, you can then become eligible for Dropbox. But again, the Dropbox is case by case. Some qualify, some they ask you to go in person. Sometimes Dropbox is not necessarily the best thing to do because they are, in some instances denying it because they don't have a chance to interview you. So if they have any questions and they send it into administrative processing. So that's the disadvantage of the Dropbox. But of course, we know there are a lot of advantages also. So yeah, you should qualify for Dropbox. But again, it's a case-by-case decision that the Department of State makes.
Okay. I got selected in H-1B registration lottery after stamping. Can I look for a job remotely from outside India, but not in USA?
H-1B registration after stamping, can I look for a job remotely from? Why do you need a H-1 then if you're not going to be working in the US? You don't really need a H-1. You can look for a job. You can work from India. You're free to do whatever you wish. You're not subject to the immigration laws of the United States unless you are living in the United States and working in the United States. So you can do whatever you wish.
Okay. The registration status is still showing as processing instead of selected or submitted. Would you like to discuss what to do in this situation, or should we wait until it changes?
So it says submitted because it will continue to say submitted, which means that your lottery, your registration was not picked under the lottery for this lottery. So what will happen is USCIS, after all the cases have been filed, if they find that there are still numbers available, they might conduct another lottery, which will only be after June, because June 30th is the last day to file your H1 if you've been selected under this lottery. So if they do another lottery, then if you get picked, then your submission status will change to selected. If they decide not to do another lottery, then they will change your status, submitted status, to not selected, and then then that you're done for this year, and you should apply for your registration again next year. So for now, you have to wait.
All right. I do see there are a few more follow-up details that we're getting. Prashanthi, do you want to pick that offline for the interest of time, or do you want to continue?
Let's first go with the questions that have not been asked.
Yes,
if you have any.
I think we've covered all the questions from this chat. I do have a few questions from offline sources as well.
Right, they've asked, I think they've asked on LinkedIn, etc.
Yes.
So maybe some of them we can cover, then come back to
Yes.
this if we have time.
Okay. All right. One of the questions we got from LinkedIn is, I got a concern related to the H-1B lottery selection under master cap.
I think
FYI.
this question was asked, I think he asked the question in the chat also.
Oh, okay, great. So we'll just move on to the next one. I have been selected, and let me know if this is asked as well, but I'll just read it out. I have been selected for H-1B lottery, but my OPT is valid for 2 more years, which I want to use. My present working company is different from where I filed my H1. I want to use my H1 after my OPT expires. Is it possible if H1 filed company supports?
Right. Not asked, but a similar question was asked. So they want to continue on F1, but still file H1, and that is possible. And make use, because the registration was picked, so they want to make sure they don't waste the registration, which makes sense, because you don't know if you'll be picked a second time. Very difficult to be picked the first time itself. So I would suggest you file your H1 consular processing, so that you don't have to immediately change your status from F1 OPT to H1, and you can continue on your F1 OPT. And then when you want to move to a H1, you have to leave the country, get a H1 visa stamped, and then come on a H1. Or you can also file a change of status from an F1 to H1 in the future, and show that you're cap exempt based on the H1 approval that you will get at this point once you file.
Okay. We only have probably a couple of minutes left. I'm coming back to the chat thread. There are a couple of questions. I'll quickly throw them at you. Can 2 H-1B petitions filed from 2 different employers?
Yes, if you're this is related to the cap, then if you file your registration with 2 employers, and if they are not related, then you can file, your registration is picked, then actually both your employers get to file your H1 if they want to. So yes, both can file, and then you can decide which one you want to keep, and the other one has to be withdrawn. Either way, even if it's not cap, then both H1s can be filed. But in that situation, then the last action rule comes to play, which means that whatever H1 you file last, that will take precedence unless it's withdrawn. So just keep that in mind.
Okay, and we'll take the last one. Does my sponsor may ask me to pay any charges for filing H-1B after selected in lottery?
They're not supposed to ask you to pay. That's against the law, so just be wary of that.
Prashanthi, do you have a couple of more minutes? We still have some questions coming in.
Yeah, we can ask the remaining questions.
Okay. Is the passport-based H-1B lottery started?
Yes, we've done the registrations have been done. The lottery has been picked. The results came out, in March, and the H1s are being started as of April 1st. And that was the passport-based lottery. They're doing it based on the unique passport number they're picking. So no matter how many times the registration has been done, how many registrations have been filed for the same person, only one case will be picked based on their passport ID number. That's what they're talking about when they say passport-based H1 lottery.
Okay. Next is my employer filed an H-1B transfer. However, when I got the I-797, it shows my citizenship as unknown in brackets. When filing with my previous employer, my citizenship showed correctly, bracket closed. Will this cause an issue now or traveling?
It shouldn't. I think it's just an error on their part that they put that. It shouldn't have any bearing on travel, etc., because you are traveling with your passport.
Do we need to be in the USA looking for job with H-1B visa, or can be outside USA?
You could be outside the USA, secure a job, and then come to the USA once your H1 gets approved.
I'm just going through the message chain. I think it's just subsequent information there. Yeah, to what I can read, Prashanthi, these are follow-up information. No specific question unless I'm wrong here. And then again, for everyone who are asking questions and or sharing more information, if you're not able to get you the specifics, this means that you can certainly come back to us and book a consultation. If you are unable to book a consultation via our website for any reasons, you can drop us a message on LinkedIn and we'd be happy to contact you. So yeah, on that note, we'll wrap up today's session. And once again, thank you so very much for attending this webinar.
Don't forget to subscribe to our videos if you like what you see. Also give us a thumbs up and share the video with your family and friends. Thank you.